Thank you, Madam Speaker, and good morning.
Good morning, sir.
If I may, a few questions through you to the proponent of the bill.
Please prepare your questions, sir.
Thank you, Madam Speaker. I think I've done a good job. I had a host of questions. I've tried to pluck my yellow stickies as best I can as people have worked through it, and I apologize if I missed a few. But I'm going to work through the bill, just a few questions, if I could. Through you, Madam Speaker, to the gentleman. I'm looking at lines 168 through 172, which I believe it's section, it's probably 2, but it doesn't matter, I.1. It speaks of how no member of the board or any officer shall directly or indirectly have any financial interest in any corporation that has, or entity, that contracts with the authority. Through you, Madam Speaker, what, if any, prohibition does this bill have against any officer, agent, or employee of the authority who may be a major investor in one of the investment vehicles of the fund, or a fund that's run by the, or used by the authority? Through you, Madam Speaker.
I think I was asked a yes or no question, and I don't think that either yes or no is the right answer. Could try again, and I'll try harder, please, if it's okay with you, Madam Speaker.
Representative Shaban.
Thank you, Madam Speaker. Yeah, I had asked a question about potential conflicts of interest in having a substantial ownership interest in some of the investment vehicles that this authority may have, and the gentleman said, well, that's covered by the fiduciary responsibilities governed in ERISA. Through you, Madam Speaker, is it the gentleman's response then that this, or the provisions of this bill are in fact covered by ERISA? Through you.
Representative Terciak.
Thank you very much, Madam Speaker. Aside from the amendment we accepted as friendly earlier, there are no violations of ERISA in this bill, is what we're being told. And in terms of the state involvement, what this bill is the state being involved in saying who can and cannot be involved, be a member of the board or an officer of the employee of the agency. Through you, Madam Speaker.
Representative Shaban.
Thank you, Madam Speaker. Well, I guess it's a little bit of apples and oranges, asking if there's a violation of ERISA or, in fact, the provisions of this act are covered by ERISA. I think the answer stands on itself that the potential conflicts with someone on the board, at least legislative authority, legislative intent, the fiduciary responsibilities, to the extent there are fiduciary responsibilities, are in fact triggered by what I heard, federal regulation and ERISA. I think it's interesting that the basic construct of what we're talking about here follows almost verbatim the definition under ERISA for what an employee benefit plan is. And if anyone has had the unfortunate experience of having been involved in ERISA law or ERISA litigation, will know that you run aground, or you run afoul of ERISA preemption, because in fact it's quite broad. Because in fact the Supreme Court and all our federal courts and the Connecticut federal courts and federal courts all around the country since 1974 have established and defined the breadth and the scope of ERISA preemption. And I fear, Madam Speaker, that we are running dead afoul of exactly that. Now, again, you've heard me stand generally in this spot. I move around a lot, talking about states' rights and what the state can do and can't do vis-a-vis federal law. And if it's the intent of the state of Connecticut to say, you know what, federal government, we don't care what you say. We don't care how we're going to treat our employees or how you think we should treat our employees. We're going to do it our own way. Well, that's one thing. That's quite a broad statement. It might violate 35, 40 years of federal precedent, but I'm a states' rights guy. I kind of like that. I think that's a bold statement. I think the state of Connecticut does have the authority to pull back some of the federal preemption that we've ceded to the federal government over the last 30, 40, 50, 60, 70 years. But here we're faced with a bill that tacitly admits at lines 213, 214, and 215 that, you know what, we know this thing runs afoul of ERISA, but we're going to put some savings language, put some new language in here. This is new language. This wasn't in the original bill, that says, well, whatever we got to do to make it right, we're going to do it. Doesn't say what you're going to do, doesn't say how you're going to do it, but the gentleman was very clear that what's happening here is we are establishing an employee benefit plan that is going to be deferred income until someone retires. That is covered by ERISA. That is on all fours with ERISA preemption. And through you, Madam Speaker, has the Attorney General offered an opinion on this amendment?
Representative Terziak.
Thank you very much, Madam Speaker. I haven't asked him if he sent me something during the debate. I haven't paid attention and received it, and no, he hasn't. As far as I know, he hasn't reached out to me with an opinion. If he's voiced an opinion to somebody else, I'd have no way of knowing. Thank you very much, Madam Speaker, through you.
Representative Shaban.
Well, thank you, Madam Speaker. So when the amendment was drafted in lines 213, 214, and 215 to require this board to take affirmative action to make sure this thing does not run aground of the federal preemption laws under ERISA, did anyone on that drafting committee or the body or the committee actually get legal advice to how that could be done? Through you, Madam Speaker.
Representative Terziak.
Thank you very much, Madam Speaker. Yes, through you.
Representative Shaban.
Thank you, Madam Speaker. And was that legal? And what was that advice to the extent? Was it from the Attorney General? Through you, Madam Speaker.
Representative Terziak.
Thank you very much, Madam Speaker. If it had been through the Attorney General, I would have said that was the Attorney General's response and advice on this issue. But no. Thank you.
Representative Shaban.
Thank you, Madam Speaker. Well, I suspect we're going to get some advice and input from the Attorney General soon on this, because this chamber may remember 3, 4, 5, 6 years ago now when we were doing a captive audience bill that ran aground of the National Labor Relations Act of 1934. I think I was standing right here with Representative Berthel was, and we had this exact same discussion about whether anyone had actually run these bills by the Attorney General to see if in fact they are legal under our federal construct. The answer then was no. Guess what happened? Attorney General months later said, guess what? You can't do that. And that went away. I fear this is what's probably going to happen here, but not to belabor the point, through you, Madam Speaker, are the assets in this IRA exempt from bankruptcy? Through you, Madam Speaker.
Representative Terziak.
Thank you very much, Madam Speaker. The assets in this IRA are exempt from bankruptcy or not exempt from bankruptcy, exactly as assets are in IRAs. Thank you, Madam Speaker.
Representative Shaban.
Well, thank you, Madam Speaker. And that, too, is another telling response because, in fact, IRA benefits are exempt or not exempt from bankruptcy, depending typically on the state law in which they exist, unless they're covered by ERISA. Because under ERISA, they would be exempt from, or they would be subject to bankruptcy protection. They could not get attached by creditors. But here we go. We go from having a standard IRA, which puts in pre-tax dollars, to having a Roth IRA, which puts in post-tax dollars. You know, we're actually using all the fancy words you typically hear in an ERISA discussion: defined benefit plan, defined welfare plan, and I suspect the Attorney General may be looking at this as well. But when it was originally drafted as a traditional IRA, pre-tax dollars going in, the relatively low-income people that this bill is supposedly designed to protect actually got the protection, or actually got the benefit, I should say, get the benefit of having a, let's call it forced retirement thrust upon them pre-tax. Pre-tax. That's kind of cool. You know, you put in $50 and guess what? That $50 comes off your tax return. But unfortunately, that generated a fiscal note for the state of, I think somewhere, it was a non-fiscal note as I recall. It showed between like $0 and $10 million. It was this massive span, but basically what it was a fiscal note, because if you're putting in pre-tax dollars, well, guess who doesn't get the money? The state. So we changed the bill. Let's protect the state. We had this discussion last night. We were changing bills last night. Let's protect the state. So instead of protecting or benefiting the supposed employee that we're trying to benefit, we protected the state and changed it to a Roth IRA where it's post-tax dollars. So now people with low income, the people that this is actually designed to help, aren't getting the help that they want or they need, or they could have had, frankly, if we were actually willing to do this as a traditional IRA, or for that matter, have their employer do it, or for that matter, get their own IRA, or for that matter, have a traditional ERISA plan. But I think it's notable that this amendment basically cut the legs out from under the people that this thing's supposed to protect. In fact, what it did is to protect the state from a fiscal impact because, as we've heard all night and all month and all session, we're in a bit of a jam financially, and that can't happen. So it's a little broader than just the payment of benefits. Now, if you look down in Section 6, there's a whole list of duties. Duty of care, theoretically. In fact, I think the original bill delineated them a little better than what's done in the amendment. But regardless, says what the authority can and cannot do, should and could not do, what duties they should take, prudent investments, that kind of thing. Well, you don't have to be a lawyer to understand that if you have an obligation but you have no liability for the breach of the obligation, you don't have an obligation. The right-duty analysis is the central thesis of Western law for the last 600 years. So what we've done here is say, you have a duty, but guess what? You don't have a liability, ergo, guess what? These retirees don't have a right. Where there is no duty, there is no right. And that is just black letter, first week law school stuff. And guess what? That's also common sense. You have the obligation to do X, but guess what? If you don't, no big deal. But here it is. We're taking a lot of money. A lot of money. It's not a forced, but it's you got to opt out. Taking retirement money from people who may not know better. But at the same time, if these folks, some of the other folks suggested, let's put them in a traditional Roth IRA or a better IRA, or give them some basic, some help getting to a spot where they can actually invest and save for the future. Well, guess what? When you do that, when you go to a Lehman Brothers, which is now gone, or you go to a Vanguard, or you go to Fidelity, they've got obligations, but you also have rights. They also have liabilities, whether it's fiduciary or otherwise. Here, we are saying that this authority that we're setting up can't be sued. There is no liability. You have, do the best you can with all these people's money, but if you screw up, no big deal. There's a harm, but there isn't going to be a foul. That's not good public policy. That's, in fact, horrible public policy, and I'm not even sure it's legitimate under our state constitution. But we'll talk about, Attorney General will pass on that one as well. Well, thank you, Madam Speaker. Unfortunately, I thank the gentleman for diving in. I know you've been up for a long time, but that doesn't do it. That doesn't do it. The plain language of that sentence does not do it. There is no language in this thing that says this authority cannot seek insolvency protection. So here's what we have. We have forced employee savings. That's going to be another burden on our employers. We've got opt-out provisions that may or may not get picked up, especially on small employers or people who are just working part-time. We've got a provision that at least gives the indicia of protection of the state when there is none. We have a program here that gives the indicia of protection of the state or the protection of ERISA or other federal laws where there is none. We have a provision here that's going to take people's money, which is not protected like it would be under an ERISA program, under SIPC or other federal paradigms. We have something here that all this does, frankly, is give the state a little bit more money. Through you, Madam Speaker, the last question, if I may. When the authority gathers the funds and whatever they have to do for reporting, I know there's reporting requirements in here, where is that amount of money going to be booked? Is it going to be on the state's books or off the state's books? Through you, Madam Speaker.
Representative Tersiak.
Thank you very much, Madam Speaker. The state puts money on its books when it's the state's money. The authorities have their own books. That's where they put their accountings. Thank you, Madam Speaker.
Representative Shaban.
Well, thank you, Madam Speaker. And frankly, I appreciate the answer, but I wish that was the case, because I know, in fact, the last budgets I've seen for the last 6 years, we've actually budgeted for things such as cheats, which, guess what? That isn't state money. In fact, the money doesn't even exist until someone doesn't do something that gets a refund back, that gets cycled back up to the state pursuant to a statute which doesn't exist. But guess what? We budget for that. We budget for that. And it is considered on the books. In fact, when we were talking about spending cap requirements, we were moving dollars on and off book to figure out what was in fact required. Through you, Madam Speaker, this really is the last question. You prompted it. Would any of these monies, if the gentleman knows, we may not have thought of this yet, would any of these monies be counted in any way, shape, or form to the state spending cap in terms of the gross dollars on hand? Through you, Madam Speaker.
Representative Tersiak.
Why, thank you, Madam Speaker. Through you, no.
Representative Shaban.
Well, thank you, Madam Speaker. That is the best news that I have heard in the last 40 or so minutes, and I know the gentleman's been up a while. This is a tough bill. I think it's a bad bill. I think a state, you've heard it before, I'm not going to repeat it, but in the fiscal condition we're in, the last thing we should be doing is establishing a state program to impose another state mandate so we can manage more of people's money. I think it's the wrong way to go, but I thank the gentleman's longevity and tenacity, and I urge rejection. Thank you, Madam Speaker.